Good afternoon, ladies and gentlemen. On behalf of the European Judicial Training Network, EJTN, it is our pleasure to welcome you at EJTN's webinar, Upholding the Rule of Law in Practice. EJTN brings together judicial training institutions from all European Union member states and supports the interests of over 120,000 European judges, prosecutors, and judicial trainers across Europe. The aim of EJTN is to help foster a European era of justice and to promote mutual recognition and trust between judicial systems and practitioners. This webinar is part of the Rule of Law project of the EJTN, financed by the Justice Programme of the EU, implemented during 2018 and 2019. The project consists of a series of seminars and this particular webinar addressing different aspects of fundamental rights and the rule of law for judges and prosecutors from EU member states and the 6 Western Balkan countries. Some of you may have already participated in one of the previous seminars organized on this topic. The aim of this webinar is to provide you with a deeper understanding of the rule of law and those aspects of the rule of law that are most pertinent for your daily work as judges and prosecutors. My name is Jana Gajdosova. I am Head of Sector Access to Justice, Research and Data Unit at the European Union Agency for Fundamental Rights, and I will be your moderator for this webinar. Our agency is a body set up by the EU in order to advise on the protection of fundamental rights in the EU. And indeed, fundamental or human rights are an essential component of the rule of law. So what is actually rule of law? Is there a single definition of rule of law? Well, if you put 5 rule of law experts in the room, you will get 5 different definitions. And so therefore I find it particularly useful for the discussion today, but hopefully also for your daily practice later on, to refer to elements of the rule of law as identified by the Council of Europe's Venice Commission. The Venice Commission has said that at its core, the rule of law is about ensuring respect for the principle of legality, the principle of legal certainty, prohibiting arbitrariness, ensuring access to justice, respecting human rights, avoiding discrimination, and promoting equality before the law. If we take just those elements as a definition of rule of law, typically, I would go a bit broader than that, but if we take just those elements, we see very clearly the extent to which we face problems right across the different countries of the continent of Europe. There are threats to the operations of courts in some places, pressure and compromises of the independence of the judiciary in other places, interferences with the work of prosecution service. It is for these reasons that I think this webinar is extremely timely and also particularly appropriate among judges and prosecutors, who are the key guardians of the rule of law and at the forefront of protecting it. It is for this reason that it is important that you are provided with relevant ammunition to be able to understand what aspects of the rule of law are key to your work and why, and be able to recognize any symptoms of malfunctioning in order to be able to act as the protectors of rule of law in your individually constituencies. To help you gain such a deeper understanding of these issues, EJTN invited 2 indeed very distinguished speakers, Professor Laurent Pech, a professor of European law and head of the Law and Politics Department at Middlesex University London, and Professor Paul Craig, professor of English law at St. John's College, Oxford. Professor Pech will frame the rule of law in the context of existing law at the EU, Council of Europe, and UN level, the hard as well as soft law instruments. And Professor Craig will then provide an overview of the relevant selected case examples from the jurisprudence of the Court of Justice of the European Union, as well as the European Court of Human Rights, focusing particularly on judicial independence and prosecutorial autonomy as one of the key building blocks of the rule of law concept. Before I invite Professor Pech to take the floor, one small technical instruction, especially for those experiencing the webinar setup for the first time. You can interact with the webinar through typing your questions and observations in the chat box. I can see that most of you already discovered the chat box and indeed already sent hellos and added the countries they are coming from, joining us from. Those of you who haven't tested it yet, please now provide us with a country name you are currently at, so you can test it. How does it work? This chat box can be used for asking questions related to the contents of the webinar throughout the whole webinar. The questions will be collected, and we will try to answer as many of the questions as possible during the presentation and at the end of the presentations. So I see some comments are being added. That's excellent. So please try it so you get a feel. And as I mentioned, please feel free to use it throughout the webinar. A second practical or housekeeping rule I would like to share with you is that when we close our webinar, you will see a URL link from your screens to our online survey about this webinar, a kind of a feedback form. Please do complete the survey, as the received feedback will help improve and shape EJTN's future webinar program. We take it very seriously, so please try to share your experience, your feedback with the webinar and afterwards. Also remember that at the end of the session, you will receive a link which will allow you to re-access to the presentations held. Now it is my great pleasure to turn this webinar over to our first presenter, Professor Laurent Pech.
Good afternoon, everyone. It's a great pleasure to be able to give you an overview of the meaning and the scope of the rule of law in the European legal space. I have three main objectives in the half an hour allocated to me. The first objective, the first aim of my presentation is to give you some clarity on the meaning and scope of the rule of law from the point of view of the Commission of the EU and from the point of view of the Venice Commission of the Council of Europe. And then I will give you an overview of the main treaty provisions regarding the rule of law in the EU treaties. And then I will finish my presentation with an overview of the main rule of law instruments which have been devised by EU institutions. And I will finish with two concrete examples of recent cases just to give you an idea of flavor of how these instruments have been used. So to begin with, the meaning and the scope of the rule of law. When we teach the rule of law to first-year law students in the UK, they quite often complain to their lecturers, regardless how good their lectures are, about the rather uncertain borders of the concept. And they do so despite the great articles we give them to read, including the wonderful article by Professor Paul Craig on the formal and substantive elements of the rule of law, which formal and substantive conceptions of the rule of law. It's an article which was published in 1997 in Public Law, and I would recommend you to read this article after this presentation if you want to know more about the different conceptions which have been debated in academia regarding the rule of law. So the bottom line is the rule of law, as was said, during the introduction, the rule of law can mean different things, but at the end of my presentation, I would like to make the point that, in fact, the core components of the rule of law as far as EU law and ECtHR law is concerned can be said to be quite consensual, but I guess we can debate this during the Q&A. So regardless of whether the rule of law can mean different things, I think it's fair to say that most scholars, most lawyers, most judges, most prosecutors would tend to naturally view the rule of law as a good thing. And to understand why most people would claim or would tend to think that the rule of law is a good thing, broadly understood, well, you have a summary of essentially why the rule of law is so important on the slide. This is an extract from a book from 2005. And as you can see, you don't have to agree, but according to these two academics, when the rule of law is weak, then democratic societies tend to crumble. And you have an explanation of the main concrete impact of essentially what happens in a society where the rule of law is threatened, weakened, or undermined. And as you can see also by reading this paragraph, there is a clear link between the rule of law, according to these two professors, and the democratic quality of societies. And I would argue, and as we shall see, in fact, in the EU at least, and in the Council of Europe, there is also a clear connection between the rule of law and respect for human rights. So the meaning of the rule of law can be quite open-ended, according to some academics, but at the very least, most people tend to think it's a good thing, even though you can find books on what I can call the dark side of the rule of law, but we don't have time to get into this. So it's a good thing. And what is also striking is that even if you look beyond the EU or beyond the Council of Europe, the rule of law has been described as possibly the most consensual concept or ideal, because unlike democracy or respect for human rights, in fact, non-democratic societies or non-democratic regimes also tend to claim compliance with the rule of law. So to that extent, it has been argued by Professor Tamanaha in a very good basic introduction to the rule of law that no other single political ideal has ever achieved global endorsement. That has been true since the end of, since the fall of the Berlin Wall, essentially. So in the early 1990s, a lot of constitutions and a lot of political regimes proclaimed their attachment to the rule of law. So much so that almost every day since then, you can read the rule of law being mentioned in newspaper articles or in public debates. So the rule of law has very much become a part of the day-to-day political discussion. That being said, quite often when being discussed, the rule of law is used without being defined. This has led to some criticism regarding the open-ended nature of the concept itself. And this is why I think it's useful to have a webinar like we're having this afternoon. I'm in New York City currently, so it's morning for me. So essentially, it's useful to kind of get together and debate or discuss what is the core meaning of the rule of law from a legal point of view. But before I get to the European conceptions of the rule of law, I would just like to go beyond the European legal space for a minute or two, just to point out that in fact, as I said, the rule of law is quite a consensual ideal, and we have now quite a few basic working definitions of the rule of law in a number of legal instruments. Let's take the example of the OSCE, which was the first international organization to provide us with a clear, I think, in my view, definition of the basic understanding of the rule of law in 1990. So what you're looking at is essentially a working definition adopted by the OSCE in a document adopted in 1990, so about 30 years ago. What is interesting with this definition is that you can see, according to the OSCE, the rule of law should not be confused with rule by law. So essentially, what the OSCE refers to as formal legality. So the rule of law is not simply the rule of rules, to put it in a different light. What is also interesting, according to this OSCE working definition, is that there cannot be any rule of law without respect for human rights, even though academics have kind of spend a lot of time debating whether it is good or not to connect the rule of law with respect for human rights, or the two should be clearly and strictly distinguished. The UN has also, even that's less well known, but the UN has also adopted, or at least the Secretary General of the UN has adopted rather comprehensive definition of the rule of law in 2004. So what you're looking at on the slide is a definition from the UN, from a UN document adopted in 2004. And then the rule of law is identified as a principle of governance which applies to everyone. And then you have essentially a number of core components of the rule of law which are explicited in the definition. So for instance, laws must be publicly promulgated. And again, you have a reference to respect for human rights. And democracy, even though it has become a bit more controversial these days in the UN framework. Looking beyond the OSCE, the UN, you can see also, I thought it would be interesting to make a reference to the charter of the Organization of the Islamic Cooperation. Actually, this organization has changed its name, so it's now the Organization of the Islamic Cooperation. And there is a reference to the rule of law, which is not, however, defined in the charter, but at least it shows you that the rule of law is very much a conceptual, consensual, especially when you don't define it. And then for actually a more narrow definition, but I guess which can be explained by the mandate of the organization, which is the World Bank, you have here, according to the World Bank, a more a narrower definition, a more formalistic definition of the rule of law, essentially about foreseeable rules, which can be amended according to foreseeable procedures. But the bottom line here is just to argue that the rule of law is very much a consensual and arguably a universal concept, even though the core components of the rule of law can be debated. Moving on to the European dimension, is there a meaning of the rule of law? Is there a consensual meaning of the rule of law in the European legal space? I would argue that there is, or at least according to the Venice Commission and supported by the European Commission, the rule of law can be defined as a set of interconnected components. 6 of them have been distinguished by the Venice Commission in an excellent report, which I would recommend you to read. Actually, if I remember well, Professor Craig was one of the authors of this report adopted in 2011. So the rule of law, according to this report adopted by the respected Venice Commission, the rule of law, the core meaning of the rule of law is consensual in Europe. And according to the Venice Commission, 6 core components of the rule of law can be distinguished. Very briefly, the principle of legality, principle of legal certainty, a prohibition against arbitrary rules, access to justice, implying independent courts. And then, interestingly, there is also a direct connection with respect for human rights. And then, possibly more surprisingly, the non-discrimination and equality before the law is listed as a distinctive component, even though one could argue that it should be part of requirement or core component number 5. That being said, if you compare the 6 core components distinguished by the Venice Commission to the 6 components distinguished by the European Commission in 2014, what do you see? They're about exactly the same, even though the phrasing has been used differently. But it's quite interesting to see that the European Commission did not decide to adopt a different definition, and I think it was correct because the core components identified by the Venice Commission are very much the core components of the rule of law you can extract, for instance, from the case law of the Court of Justice of the EU. So if you don't pay attention to the phrasing, you could argue that in the European legal space, we have, at least according to the Venice Commission and the European Commission, essentially the same definition of the rule of law as essentially being a set of 6 interconnected principles. Another interesting document, I think, which is worth reading, but then you're going to hate me because I have already highlighted quite a couple of readings for you to do. But as a complementary reading to the Venice Commission report I just highlighted, there is a very detailed rule of law checklist document, which was adopted again by the Venice Commission in 2006. So this was commissioned to the Venice Commission by the European Commission, actually, if I remember well. And the European Commission asked the Venice Commission to essentially put more flesh on the bones of these 6 core components of the rule of law, which were distinguished in its report from 2011. And the Venice Commission has produced a very useful, very user-friendly rule of law checklist. You just have a very brief example on the slide regarding one of the requirements identified by the Venice Commission regarding the independence of judiciary. And you have another example regarding the independence of individual judges. So essentially, this is a very useful document if you want to quickly assess whether your own legal system and some core elements of your legal system do comply with international European standards when it comes to the rule of law. It's a set of questions, then followed by a set of answers, and then at the end of the document, you have all the key international standards summarized. If you have to do any work on the rule of law and its core components, I would suggest to always have this document on your desk. I use it quite often myself because then he essentially has done the research for you. So something to keep in mind. There is no equivalent in the EU legal world of this Venice Commission checklist, but because there is no need for an additional document, because what the Venice Commission has done is perfectly applicable to the EU legal framework. So essentially, to conclude on the core meaning of the rule of law, I would argue that at least from the point of view of the key European institutions specializing in rule of law, the core components of the rule of law, the 6 core components of the rule of law have been identified as consensual in Europe. Core components which cannot be compromised. If they are compromised, as we shall see, there will be a number of possible instruments to be used against the culprits. But before moving on, I just also want to emphasize that in addition to these core components, there is possibly another consensual aspect worth highlighting, which is that according to both the EU and the Council of Europe, it would be wrong to view the rule of law as something which can exist without respect for basic democratic principles and with that respect for human rights. So to that extent, you could argue that this is possibly a special European approach because it's not everywhere that the rule of law, democracy and human rights are seen as interconnected, interdependent and mutually reinforcing principles. But this is very much, I think, the dominant European approach. So now moving on to something more basic. I'm just going to give you a very brief overview of the main treaty provisions, some of which have been in the news recently, so I guess it's always worth having a quick refresher of what do they provide. Article 2 TEU is the key treaty provision summarizing the values on which the EU is said to be based. This has been part of the treaty package, if I dare say, since the early 1990s. Initially, the ancestor of Article 2 only listed the 3 key foundational principles, rule of law, democracy, and respect for human rights. But as you can see, the list of values has been extended, and the last time this was done, that was done by the Lisbon Treaty. Article 2 is part of the EU law package. If you want to accede to the EU, you have to show compliance with these values. I'm going to tell you about this provision in a minute. But before I do that, I have to tell you very briefly or remind you of the existence of possibly famous or infamous Article 7 of the TEU. Again, this was not part of the initial EU treaty package. It was inserted in the treaties in the late 1990s. So, long story short, a number of founding member states, to oversimplify, were concerned about possible backsliding already then in those days. And they thought that possibly it would be good to have some sort of a safeguard mechanism which would never be used. As you know, Article 7, paragraph 1, the preventive arm of Article 7 has been triggered not once but twice in the past 2 years. 2 countries are currently subject to Article 7, paragraph 1 proceedings, these 2 countries being Poland and then Hungary. Initially, when Article 7 was inserted in the EU treaties, people used to argue that Article 7 would never be triggered, and in fact, it was described once by a former president of the Commission as a nuclear option. So essentially something you would never activate, otherwise everybody is dead. But possibly there was a misrepresentation of Article 7, because Article 7 actually consists of two different branches, a preventive arm and a sanctioning arm. So what we have activated in the EU currently against Poland and Hungary is simply the preventive arm. No sanctions can be adopted against Poland or Hungary on the basis of the preventive arm of Article 7 TEU. But Article 7, to a large extent, could be argued similar to Article 50 of the TEU, to just make a brief reference to Brexit. It was another treaty provision people thought would never be used. But here we are with both Article 7 and Article 50 having been activated. Regarding candidate countries, Article 49 of the TEU is the important provision, and it provides for any EU candidate an obligation to comply and promote the values on which the EU is based. On the basis of this treaty provision, the EU has been monitoring compliance with EU rule of law acquis. I don't know if you have heard of the EU acquis and the different chapters, but essentially any EU candidate country must demonstrate compliance with a number of rule of law standards, which are to be found in what we know as Chapter 23 and Chapter 24 of the EU acquis. Last but not least, this is a recent provision introduced by the Treaty of Lisbon, and according to Article 20 of the TEU, on the international sphere, on the international plane, the EU must promote the values to be found in Article 2, including, of course, the rule of law, which means essentially EU institutions, when they act externally, are subject to a soft law obligation to promote the rule of law in their external relations. So that's another important treaty provision. Moving on to the last topic of my presentation, which is essentially an overview of the main rule of law instruments available to the EU institutions in a situation of what I call rule of law backsliding. Or essentially, when there are rule of law issues at member state level, then the EU has available to itself a number of instruments. As you can see, the list of instruments has quite increased post-2012. Now, why did I pick 2012? Because 2012 was the first time the EU Commission made the diagnosis that the EU institutions, or the EU itself, was facing a different type of rule of law threat, which it never faced before. According to former President Barroso, he spoke in this State of Union address in 2012 of a new type of threats to the legal and democratic fabric in some of our European countries. In those days, 3 countries were mentioned by President Barroso: France, Romania, and Hungary already. And on the back of this diagnosis, President Barroso said that Article 7 TEU cannot be used because it's simply unworkable. He's the one who used the label nuclear option. And he said that, rightly or wrongly, that infringement actions or enforcement actions under Article 258 of the TFEU are not effective enough. So on the back of this diagnosis, and I'm not saying the diagnosis is right, the Commission adopted a so-called rule of law framework in 2014. This rule of law framework was adopted or activated for the first time against Poland in 2016, but because it didn't work, the Commission then activated Article 7 TEU in December 2017, if I remember well. On top of this, the Council of the EU, the institution representing the member states, have also come up with their own rule of law mechanism, which is called the Annual Rule of Law Dialogue. But this is, again, just a soft law mechanism consisting of regular meetings, in fact every 6 months or at least once a year, where the national governments discuss best practices regarding a rule of law related topic. Because the rule of law framework and the annual rule of law dialogue haven't worked very well, just to put it quickly, what we have been seeing in the past 2 years is essentially the old instruments like enforcement actions and preliminary rulings being used to essentially effectively or more effectively deal with what I have described as rule of law backsliding. My time is limited, so I'm just going to give you 2 examples of 2 important cases, which I'm sure Paul Craig will detail in his own presentation, because I think I have only 4 minutes left. So I'm just going to give you an example of a recent enforcement action and one recent example of a preliminary ruling. This is not to say that only these 2 traditional instruments can be used to fight rule of law backsliding. In fact, as you can see from my list, there are many more, and in fact my list is non-exhaustive. But it has been argued, and I think to a large extent this is correct, that all of the other instruments have proved to be rather ineffective when you're dealing with a government who is deliberately, intentionally trying to undermine the rule of law. The rule of law framework, for instance, of the Commission was based on the assumption that through dialogue you can solve differences, but it has proved to be a wrong assumption when dealing with a national government which is keen not to change its course of action. So 2 examples. The first one is a very, very important case, possibly the most important case decided by the Court of Justice regarding judicial independence ever. I believe Professor Craig will tell you more about this, but just let me emphasize its importance and why is it so important in a few words. This is essentially the first time the Court of Justice has operationalized Article 19, paragraph 1 of the TEU. So what do I mean by operationalizing Article 19, paragraph 1? It means that the Commission can now bring an enforcement action on this sole basis to protect judicial independence in a member state. This had been discussed in legal scholarship for quite some time. It was initially the view of the Commission that enforcement actions could not be exclusively based on Article 19, paragraph 1. The Court of Justice disagreed with this view. And in fact, what does that mean? It means that should the Commission be of the view that the national government is targeting specifically the national judiciary, an enforcement action can be brought. So the outcome of the Portuguese ruling case is not that important from our point of view. What is important is more the reasoning of the Court of Justice in this very important case. It does mean, and in fact, it led the Commission to bring directly another infringement action against the Polish government regarding the Polish law on the Supreme Court on the basis of Article 19, paragraph 1, in conjunction with Article 47 of the Charter. But you don't have to bring a case based on these 2 provisions. You can just bring an enforcement action theoretically on the back of the sole basis of Article 19, paragraph 1. This is a rather revolutionary ruling from my point of view, very important, because it means also that national judges can bring preliminary rulings on the back of Article 19, paragraph 1. And in fact, the Portuguese ruling was a preliminary ruling. On the back of this Portuguese ruling, just to very briefly, I know my time is up, we have about 9, if not 10, preliminary ruling cases pending before the Court of Justice, which are originating from Polish courts. This would not have been possible if there was no Portuguese judge ruling. Essentially, we have seen a number of Polish courts asking the Court of Justice, we have yet to see judgments, asking the Court of Justice to review a number of Polish measures on the back of Article 19, paragraph 1 TEU. This would not have been possible before this preliminary ruling in the Portuguese case. Now, last but not least, but I believe also Professor Craig is going to talk about this case. This is a very important infringement action. So the first Portuguese judge ruling was a preliminary ruling case. This one is an infringement action. The first time, essentially, that the Commission has brought an enforcement action on the basis of Article 19, paragraph 1 of the TEU. And the first time, as far as I know, that the Court of Justice issued an interim ruling in which he referred to not only the principle of judicial independence, which was already a traditional principle of EU law, but the principle of the irremovability of judges. That's the first time I've seen this principle mentioned in the case law of the Court of Justice. Another, as far as I know, another unprecedented reference is the reference to the notion of serious and irreparable damage to the EU legal order. We are waiting for a judgment on the merits. The judgment on the merits in this case is expected to be issued, I believe, possibly in May or June. So thank you very much. That does conclude my presentation.
Thank you very much, Laurent, for your very interesting presentation. Now we can move to the questions and answer session. So if you have any questions you would like to ask Laurent, please type it now in the chat box that you used at the beginning when you entered the room to say hello. You can collect quite a few, and we have approximately 10 minutes to spend on addressing the questions and before moving to another presentation by Professor Craig. Maybe to give you time to type your question, I can start with my own comment or in fact a question to Professor Pech. I would like to ask you mentioned the very important case, Portuguese case, which I think gives our webinar participants a clear idea what tools are available to them in the context of the EU legal framework. While the previous slide mentioned relevant tools available to the EU institutions to fight and defend the rule of law, the preliminary ruling is indeed a way for the national judges to pose a question and defend the rule of law in their own national legal orders. To what extent you believe, you slightly alluded to that already, but to what extent you believe it was important that the argument was not just based on the Treaty on the European Union, but also linked with the Charter, which is also the primary law. Is it something that you would advise our judges to do when they want, for instance, to pose a request for a preliminary ruling? Does it strengthen? Does it help? Is it an extra argument? Or yes, your views on that would be very interesting to hear.
So it's a very good question, a very difficult question, but very briefly. And before I actually answer the question, I'm just going to share a link to a post, a brief post I wrote on the Portuguese case ruling, in which I made some practical recommendation to national judges which are under threat through national measures targeting their independence. So just to go back to your question. It used to be that the Commission was of the view that you could only initiate an enforcement action, or that national judges could only ask questions to the Court of Justice relating to Article 47 of the Charter and not Article 19 TEU regarding judicial independence. So essentially, the view was Article 19 was too broad, too general to be applied in a case. However, Article 47 of the Charter was essentially made legally binding to guarantee the right to fair trial and the principle of effective legal remedies in every single individual case. So Article 47 of the Charter has always been possible, at least since the Charter became part of the EU law framework, has always been actionable. So you were always able to bring a case based on Article 47 of the Charter, subject to one actually confusing and controversial condition, which was that you could only rely on Article 47 when the case, the national case, fell within or is said to fall within the scope of EU law. Now, we're not going to get into details of what is the meaning of this notion of scope of EU law. I used to do judicial trainings, spending a day explaining to judges and prosecutors how do you apply this concept of meaning of EU law. But the important point about this notion of scope of EU law is that in this Portuguese case, the Court of Justice has decided that Article 19, paragraph 1 of the TEU can be applied even in a situation where the case doesn't fall within the scope of EU law. Now, this is a bit technical, but according to the Court of Justice, Article 19, paragraph 1 of the TEU has a different scope of application than Article 47 of the Charter. In the Portuguese case, Portuguese judge case, the court referred to the notion of fields of EU law, which is actually the notion mentioned in Article 19, and did suggest or did strongly imply that the scope of application of Article 19, paragraph 1 is much broader than the scope of application of Article 47 of the Charter. So to understand this, essentially, it means that any kind of a structural targeting of judicial independence at the national level can easily fall within the scope of Article 19, even though it might not trigger the application of Article 47 of the Charter. I'm not sure whether this is clear enough, but this is a very important case. And essentially, it means you can certainly raise both provisions, but you don't have to. And the scope of application of Article 19 is broader than the scope of application of Article 47
Laurent,
of the Charter.
that was very, very clear and very useful. And thanks very much also for sharing the link of your commentary on the case. I don't see any further questions, I would now suggest maybe to move to another presentation. There will be time for questions also after that presentation.
Mm-hmm. Yes, I'm going to listen to the next presentation, and participants should also feel free to email me questions
very good. But
by
please, also
email
for the sake
of
a discussion and others, don't be shy and use the chat box. It's always nice to hear your views, and especially from the national level, the practical daily work and daily problems you're facing. And you might easily get an answers and help ideally for those things. So please go ahead. Now let me once again thank Laurent for the presentation, and let's move to our next presenter, Professor Paul Craig, who will be providing a brief overview of practical examples from the jurisprudence of the Court of Justice of the European Union, as well as the European Court of Human Rights, on the rule of law, and particularly as regards the independence as one of the aspects of the law that is most pertinent for your work. Professor Craig, the floor is yours.
Thank you very much indeed. I'm just waiting for the slides to come up. Thank you very much, Jana. It's a great pleasure to be here. It's a great pleasure to be sharing a virtual platform with Laurent as well, and to be speaking to the many judges and prosecutors from different European countries. So my presentation is intended to complement that of Laurent, and what it's intended to do is to look in a little bit more detail at some of the case law. Laurent has given an excellent presentation setting out some of the concepts of and conceptions of the rule of law which are applicable in the various papers and rulings on this issue. I'm going to go into a little bit more detail about some of the case law concerning the rule of law flowing both from the Strasbourg Court and also from the European Court of Justice. So just to put things in perspective, there are, as is clear from the presentation from Laurent, many different aspects of the rule of law. And that's evident from the document to which Laurent referred from the Venice Commission and from many of the other writings about the rule of law. And it's certainly not possible within the time that I have available to consider the case law relating to all such facets of the rule of law, each of which would occupy more than the 30 minutes which have been allotted to me in this seminar. So the discussion which I'm going to deal with will concentrate on key case law from Strasbourg and the Luxembourg courts concerning the rule of law and judicial independence, because that's particularly relevant to the participants of this seminar. So that's what I'm going to concentrate on, and I'm going to begin with some of the Strasbourg jurisprudence, and then I'm going to look at some of the jurisprudence from the Court of Justice, and in particular I'll be looking in relation to the latter jurisprudence at, or in more detail, at the cases to which Laurent referred at the end of his presentation. I think just as a preliminary note here, what I've done in this presentation is to go into some detail about the reasoning of the Strasbourg and Luxembourg courts concerning the application of the rule of law in the context of judicial independence, because it's only by doing so, it's only by breaking down the court's reasoning and understanding it in its more granular or detailed aspects that one can really understand that reasoning and understand its significance and apply it in later cases which may be of relevance to the different judges and prosecutors who are attending this seminar. So let me begin with the well-known and controversial fact situation which gave rise to Bakker and Hungary. So in this case, the applicant alleged in particular that he had been denied access to a tribunal to contest the premature termination of his mandate as president of the Supreme Court. And he also complained that his mandate had been terminated as a result of the views and positions that he had expressed publicly in his capacity as president of the Supreme Court concerning legislative reforms affecting the judiciary. And basically, the court considered the case based on the basis of a violation of Article 6.1 of the Convention and also a violation of Article 10. Now, as participants in this seminar would know, there have been controversial moves in Hungary concerning the judiciary. I'm not intending to pass judgment directly on those. I'm retailing and relating the reasoning of a case which arose out of those legislative changes. But just to put it in the background here, and this was taken account of by the Strasbourg court in its ruling, there had been a number of different reports by different kinds of bodies looking into the changes made to the Hungarian legal system. And the reports were made by bodies such as the Venice Commission. I am the alternative UK member of the Venice Commission, and so I've been involved in the Hungarian legal system in that capacity, though I did not actually I was not part of one of the teams making reports specifically about the Hungarian legal system, but I, of course, saw all those reports in plenary session. But not only the Venice Commission, but also the CJEU and the Hungarian Constitutional Court have been involved. The Strasbourg Court also, in its judgment, by way of background, referred to multiple texts from the United Nations, the Inter-American Court on Human Rights, as well as the reports from the Venice Commission. So just to remind ourselves, Article 6.1 The applicant complained that he had been denied access to a tribunal to defend his rights in relation to his premature dismissal as president of the Supreme Court. And he contended that that dismissal was the result of legislation at a constitutional level, which deprived him of any possibility of seeking judicial review even by the Constitutional Court, and claimed that this was a violation of Article 6.1 of the Convention. So what I have done in relation to Article 6.1 is to disaggregate, break down the different stages of the court's reasoning about Article 6.1. You won't find bullet points of this kind in the actual judgment, but I have. This is merely descriptive, it's not normative, it's presenting the reasoning of the court as the court itself presented it, and the brackets at the end of each of these bullet points refer, of course, to the paragraphs of the Strasbourg Court's judgment. So this was the reasoning about Article 6. What the court said is that there had to be a violation of a civil right for the purposes of Article 6.1, because that's how it's framed, but that the article itself, Article 6.1, does not itself create any particular substantive rights in the contracting state. So that's absolutely fundamental for understanding Article 6, and indeed confusion in that respect has, or uncertainties in that respect have created confusion in some other cases. What the court then said is that in the light of the domestic legal framework, which was in force at the time when the president was elected and during his mandate, the applicant could arguably claim to have had an entitlement under Hungarian law to protection against removal from office as president of the Supreme Court during that period. So that was in paragraph 109, and then they continued, the new legislation, they said, could not take away the pre-existing right, since its legality was the very object of the dispute in the present case. So basically the court saying he had a substantive right, and the new legislation could not in and of itself take away that right, because it was that legislation which was in dispute in the existing case. The court then continued in paragraph 117 that national legislation excluding access to court had to be compatible with the rule of law, I apologize, I think my connection just got lost for a moment. That then meant that, I apologize, I think my connection could not, my connection failed momentarily at my end, I apologize. So what the court then said is that national legislation excluding access to court had to be compatible with the rule of law, and that meant that it could not be ad hominem. It had to be based on a law of general application. That was paragraph 117. The right of access to court fell within Article 6.1 such that the claimant's premature termination was not reviewable by any court. There was, therefore, the court concluded, a violation of Article 6.1. The court then gave its attention to Article 10, which is the famous free speech provision of the Strasbourg Convention. And the court agreed with the claimant on the facts that his termination was due to the fact that he criticized the government's judicial reforms, and that this therefore prima facie constituted a violation of Article 10. Hungary, for its part, argued that the dismissal could be justified under Article 10.2 because it was designed to maintain the authority and impartiality of the judiciary. With respect, that was a rather bold argument by the Hungarian authorities, and the Strasbourg court, not surprisingly, disagreed. It said, paragraph 156, quote, "The state party cannot legitimately invoke the independence of the judiciary in order to justify a measure such as the premature termination of the mandate of a court president for reasons that had not been established by law and which did not relate to any grounds of professional incompetence or misconduct, nor was the action against the claimant necessary in a democratic society." The court continued, and I think on the facts its reasoning was unequivocal, and rightly so. The court continued, "The impugned interference was prompted by the views and criticisms that the applicant had publicly expressed in the exercise of his right to freedom of expression. It observes in this regard that the applicant expressed his views on the legislative reforms at issue in his professional capacity as President of the Supreme Court and of the National Council of Justice. It was not only his right, but also his duty as President of the National Council of Justice to express his opinion on legislative reforms affecting the judiciary, after having gathered and summarized the opinions of lower courts." That was paragraph 168, and the court continued that premature termination of the applicant would, they said, have a chilling effect on other judges who might be thinking of commenting adversely on legislative reforms that affected the judiciary. So, a really interesting and powerful opinion by the main body of the court in the Bakker case, affirming and upholding the idea of judicial independence. There was, in addition, an interesting and scholarly concurring opinion by Pinto de Albuquerque and Dedoff. Now, I could spend an entire half an hour looking at the elegant reasoning of the two concurring judges, and I don't have time to do that, but suffice it to say for the present that the two judges raised interesting and complex arguments about what are regarded as unconstitutional constitutional amendments. Now, there is in fact a really rich and growing academic literature on the very idea of unconstitutional constitutional amendments. It may seem odd, it may seem indeed a contradiction in terms. What we would say in English is almost an oxymoron to say you can have an unconstitutional constitutional amendment. What does that even mean? Well, it means different things to different people, different writers. But it seemed, if you look at the concurring opinion in the Bakker case, the way in which the two concurring judges were using the concept was actually, I think, a correct and defensible meaning or usage of the concept. So what it really entailed, the core idea, if you stand back from the detail of the reasoning, is that an unconstitutional constitutional amendment is an amendment which in form, at least, complies with the requirement for amendment of a constitution, but is unconstitutional, notwithstanding that, because the content of the amendment offends certain substantive principles which are either explicit in that constitution or are regarded as normatively implicit in that constitution. And that's in effect how the two judges in the concurring opinion use the concept in the present case. In para 13 of their concurring opinion, what they say is Article 11.2 of the transitional provisions is in essence an unconstitutional constitutional provision in the light of the Hungarian historical constitution and the constitutional continuity of the principles of the independence of the judiciary and the irremovability of judges in both the new fundamental law and the old constitution. And that short paragraph captures accurately this idea of an amendment which is technically passed in formal terms in conformity with the requirements for amendment of the Constitution, while at the same time offending certain deeper constitutional substantive principles which are said to underlie or underpin that constitutional ordering. Before we leave the concept of judicial independence at the Strasbourg level, I think it's important, although we're focusing on the independence of the judiciary and in the context of Article 6.1, because that's the principal focus of this seminar, we ought also to be mindful of the fact that Article 6 and the Strasbourg case law is often applied by national judges in order to determine whether the organization for the delivery of administrative services at national level is compliant with Article 6. So basically, quite often what will happen is that in a particular country, the delivery of housing services or educational services will be, or planning will be entrusted to an arm of the state. It may be a minister, it may be an agency, and then there will be questions raised about whether the agency or the minister satisfies the requirements of independence which are set out in Article 6.1. And that has given rise to, and then, so it is the national judges at the front line who are making those determinations. And that has given rise, certainly in the UK context, to to difficult cases which have gone to our top court, the House of Lords as it then was, and to the Supreme Court as it now is. So there have been difficult cases about whether, if the public body was not in itself independent, whether there were in any event sufficient safeguards in terms of judicial review, whether there were sufficient safeguards in terms of judicial review in the UK system. So just looking at a question which has just popped up, just to make it clear that the titles, the Alconbury and Begum, these are the names of the cases in the UK court. So if you went onto the House of Law website and put in the word Alconbury or the word Begum, you would get the full report from that particular case or of that particular case. Or indeed, if you went on to Westlaw or LexisNexis, then you would also be able to find the case just by putting in that name. Okay, so moving on now to the CJEU. We've looked at the Strasbourg Court. Let me move my focus to the Court of Justice's jurisprudence. So what I do in relation to the Court of Justice, I have got three big cases that I'm looking at. Panicello, and then the Portuguese judge's case, which Laurent mentioned, and also the Polish case, which Laurent mentioned, and I'll be going into both of those in detail. But we start off with Panicello against Martinez, And I think the reason that I have actually separated this case out is that this case provides a very good summation of the two core dimensions of judicial independence which form the architecture of the Court of Justice's jurisprudence. And when it talks about judicial independence, it talks about an external dimension and an internal dimension. In Panichello, the external dimension is elaborated in paragraph 37, and it's clear, as you'll see from that paragraph, that although Panichello is elaborating on this, this is a well-tested formula which has been cited by courts in a number of previous cases. So this is not new, but this is just a formulation which is helpful and clear in a relatively recent case. So the first external aspect or requirement of judicial independence is that the court exercises its functions wholly autonomously without being subject to any hierarchical constraint or subordination to any other body, and without taking orders or instructions from any source whatsoever, and is thus protected against external interventions or pressure which may be liable to jeopardize the independent judgment of its members as regards proceedings brought before them. So that's the external dimension of judicial independence. Putting it very basically, no one can tell you, the national judges, what you should be ruling, and no one should be able to pressurize you to reach a judgment of any particular kind. You must be immune from that kind of external pressure. That's the external dimension. The second dimension is not surprisingly, the internal dimension. And here, what the court tells us is that this is linked to impartiality. So judicial dimension, the judicial independence in this dimension seeks to ensure a level playing field for the parties to the proceedings and their respective interests with regard to that subject matter and the subject matter of those proceedings. And what the court is getting at here, as is made clear in para 38, is that that aspect requires objectivity and the absence of any interest in the outcome of the proceedings apart from the strict application of the rule of law. So very much this idea that judicial independence means that not only are the national judges immune from external interference, pressure, or whatever, they must decide autonomously, but also when the national judges make their ruling, they really are weighing the scales of justice evenly for both sides and giving an impartial judgment. So I now turn to more detailed elaboration of two of the crucial recent cases about judicial independence, and it's not fortuitous that Laurent and I independently, if I can put it that way, both made use of and referred to these cases because they are seminal cases, and they are seminal cases very much for the reasons which Laurent has elaborated on. So let's be clear. The first of these, which is the Portuguese judge's case, was a preliminary reference under 267 of the TEU. It's an action brought by a trade union representing Portuguese judges, and they make an allegation concerning the temporary reduction in the amount of their pay. And that temporary reduction was introduced by a Portuguese law the pay reduction related to the remuneration of a series of office holders. It wasn't just national judges. And in accordance with administrative salary measures, management measures adopted on the basis of that law, the remuneration of the judges of the Court of Auditors was reduced. Obviously, putting this in context, this particular Portuguese law was part of the necessary measures taken by Portugal in order to meet the austerity requirements as a result of or flowing from the financial crisis and its effect on certain EU states. Now, the claimants in this case, who was the union representing the Portuguese judges, argued that the salary reduction measures infringe the principle of judicial independence enshrined not only in the Portuguese constitution but also in EU law. And as Laurent emphasized, and absolutely rightly so, they based their claim not only on Article 47 of the Charter but Article 19(1) of the TEU. The court then summarizes the question and says, in view of the mandatory requirements of eliminating the excessive budget deficit of financial assistance regulated by rules of EU law, must the principle of judicial independence enshrined in the second para of Article 19(1) and in Article 47 of the Charter and in the case law of the Court of Justice be interpreted as meaning that it precludes the measures to reduce remuneration that are applied to the judiciary in Portugal, where they are imposed unilaterally and on an ongoing basis by other constitutional authorities and bodies, as is the consequence of Article 2 of the relevant Portuguese law. Now again, as Laurent I think, and I agree with him entirely, as he stated in his presentation, what's particularly significant about this case isn't necessarily the outcome, because the court, as you will see, found that the Portuguese law did not infringe the principle of judicial independence, and I think they were right on the facts, but it's the reasoning of the court. I have broken the reasoning of the court down into different stages for the sake of ease of exposition. But just to make it clear, you won't see stage 1, stage 2, stage 3 in the court's judgment. But again, this is merely descriptive. There's nothing normative that I'm sneaking in here. It's simply to ease analysis. So what I'm calling stage 1, which is in paragraphs 27 to 42 of the court's judgment, is that where the CJEU acknowledges that pursuant to Article 19, national courts played an integral part in the enforcement and application of EU law, and that meant that effective judicial protection in the EU legal order demanded independent national courts, and that independence was integral to effective adjudication. Okay. Just before we move on to the next slide, let me just emphasize, because again I agree with what Laurent said, just to push this point home and to set it in a slightly broader context. What the court's saying here about the using Article 19 and then building on the back of Article 19 protection for the independence of national courts fits extremely well into, he hadn't done it before, but it nonetheless fits extremely well into the CJEU's overall vision of the role of national courts within the European legal order. Right from the very early jurisprudence back in the 1960s, the court has consistently maintained that national courts are courts of general jurisdiction for the application of EU law within their respective national legal orders. They've maintained that proposition. It is a correct proposition in my view. And they've maintained it because it was clear to the CJEU that if you wanted EU law to be effectively applied and administered, then that effective application and administration at the judicial level would be within the legal orders of the 28 member states. So when we conceive of the EU as the EU judicial hierarchy, we should therefore conceive of it not just in terms of the CJEU and the General Court, but also we should conceive of it as the CJEU, the General Court, and also all courts of the 28 national legal systems who are charged with both the power and the duty to apply EU law when it comes within their substantive realm of competence. So what the court is saying here, in a sense, what happens in the Portuguese judge's case is, in a sense, a natural, very important, but a natural corollary of that earlier foundation. If national courts are indeed central to the EU legal order, because they're central to the effective discharge of EU law within their own countries, then it follows a fortiori that the national judges must be independent, since otherwise their ability to effectively and impartially discharge EU law within their own country will thereby be impaired. So it's a natural corollary of what happened earlier, but it's an extremely important one given what's going on in some national judiciaries in some member states. Stage 2, the court tells us about the meaning of independence. Says the concept of independence presupposes in particular that the body concerned exercises its judicial functions wholly autonomously, without being subject to any hierarchical constraint or subordinated to any other body, and without taking orders or instructions from any source whatsoever. And thus it is protected against external interventions or pressure, etc. So very much taking up the same idea of the external dimension of independence, which we saw in earlier cases such as Panicello. The court then, what I'm calling stage 3, they make a linkage between independence and remuneration, where they say that, like the protection against removal from office of the members of the body concerned, the receipt by those members of a level of remuneration commensurate with the importance of the functions they carry out is a guarantee essential to judicial independence. They then applied that precept to the existing case, and not surprisingly found that it wasn't violated. They found that it wasn't violated. Why? This was not a targeted salary reduction against the members of the judiciary. The Portuguese legislature, the Portuguese executive were not trying to target the judiciary. They were not trying to undermine the judiciary. This was simply the application of austerity audits against public officers in general in order to meet financial constraints imposed on Portugal. And the judges, it was not an indirect method of undermining the Portuguese judiciary. So, moving on then to the Polish case, again, extremely important. So we had interim hearings an expedited hearing challenging the Polish law that changed the terms on which judges of the Supreme Court in Poland worked, changed their retirement age, and vested the President of the Republic with wide powers in that regard. And the case was, not surprisingly, heard by the expedited procedure. The court, in paragraph 16, emphasizes once again this connectedness which we had seen in the Portuguese case. They emphasize in this enforcement action brought by the Commission, they emphasize the same reasoning about the connectedness between the idea of independence and the national courts, and the importance of independence being applicable to the national courts within the EU legal order. And that comes out very clearly in paragraph 16, when they say, on the one hand, having regard to their specific duties and the authority attaching to their decisions in the national legal order, and to the particular obligation to which they are subject under the third para of 267, national Supreme Courts play a central role in the system for the application of EU law. Note there the point I was making earlier about why they play such a central role. Any doubts as to the compliance with the guarantees of independence as regards those courts are such as to prevent them fully from playing that role. So that's on the one hand. On the other hand, such doubts are also likely to undermine the mutual trust between the member states and their respective courts, necessary for the principle of mutual recognition, which plays an essential role in connection with many legal acts of the EU concerning the area of freedom, security and justice. So note here, this point about mutual trust was mentioned in the Portuguese case as well, but just to emphasize it. So what you have here is the court emphasizing the importance of independence, not only to the effective implementation of EU law within that particular state, given the centrality of national courts to that implementation, but also the horizontal dimension of independence, or the horizontal importance of independence, meaning in this context the mutual trust between different national courts. Different national courts have to trust each other to make the whole system work. That's particularly the case in the context of the European arrest warrant, where mutual trust is the key to the whole regime. But also it's very, very important in other contexts too. Mutual recognition and mutual trust is central to the horizontal dimension of the workings of the EU legal order, and the court is cognizant of that in para 16. The Commission argued inter alia that the Polish reforms cast doubt on the ability of the Supreme Court to continue to rule in compliance with the fundamental right of any individual to have access to an independent court, which was enshrined in Article 47. And the court agreed, paragraph 21, where it says it must be recalled that the requirement of judicial independence forms part of the essence of the fundamental right to a fair trial, a right which is of cardinal importance as a guarantee that all the rights which individuals derive from EU law will be protected, and that the values common to the member states set out in Article 2, to which Laurent referred, in particular the value of the rule of law, will be safeguarded. Note here again, just elaborating on para 21, seeing the significance of this, standing back from this, what this really means is, putting it in one way, what this really means is independence of courts is, if you like, a right sitting beyond other rights, or putting the same point in another way, if you don't have independent courts, then your other important rights, whether it's the right to free speech, equality, non-discrimination, religious freedom, or whatever, if you do not have independent courts, then the extent to which all the other substantive rights, which we regard as really very important, the extent to which they are protected is placed in jeopardy. And in that sense, independent courts are almost logically prior to or a necessary condition for the proper application of these other freedoms. The court then in Para 22 reinforces that and says that in addition, the uncertainties thus surrounding the disputed national provisions are also liable to have an effect on the working of the system of judicial cooperation, which is embodied in the preliminary ruling mechanism in Article 267, which is the keystone of the EU judicial system, for which the independence of national courts, particularly those ruling at last instance, is essential. Now, in a later hearing in the same case, which is came shortly thereafter, the Grand Chamber ordered Poland to suspend the relevant laws in the way that Laurent mentioned in his own very helpful presentation. I've exceeded my time, but just to say, I've been talking primarily about the independence of judges. EU law also imposes a considerable number of obligations on national prosecutors. I cannot possibly go through all the relevant case law, because that would take me much longer than half an hour or 30 minutes. Suffice it to say the following: national public prosecutors are subject to multiple obligations related to the rule of law, which flow from various substantive rules of EU law, and that is especially so in relation to the European arrest warrant, the EAW. And I've merely, given the exigencies of time, set out one of the many examples where EU law imposes obligations related to the rule of law on public prosecutors. This is the Brugger case, Gosutoken Brugger, and this was an application, I'm sorry, there's an N missing, from the ne bis in idem principle in Article 54 of the Convention implementing the Schengen Agreement. And of course, the objective of that principle is to ensure that no one is prosecuted on the same facts in several member states on account of having exercised his right to freedom of movement. That the application, the interesting application of that principle in the present case was as follows. What the court held was that principle, the ne bis in idem principle, applied to procedures whereby further prosecution was barred, by which the public prosecutor of a member state discontinued criminal proceedings brought in that state without the involvement of the court, once the accused had fulfilled certain obligations, and in particular, in that case, had paid a certain sum of money, which was determined by the public prosecutor. On conclusion of that procedure, the person concerned, said the court, must be regarded as someone whose case had indeed been finally disposed of for the purposes of Article 54. The effect of such a procedure must be regarded as sufficient to allow the ne bis in idem principle laid down by that provision to apply, even though no court was involved in the procedure, or the decision in which the procedure culminated does not take the form of a judicial decision. Interestingly, the court also emphasized that this reasoning was not dependent on harmonization of the criminal laws of the member states relating to procedures whereby further prosecution was barred. It held, and again, this was fitted with much of the reasoning of the court in this type of case, it held that the ne bis in idem principle necessarily implied that, regardless of the way in which the penalty was imposed, the member states have mutual trust in their criminal justice systems, and that each of them recognizes the criminal law in force in the other member states, even when the outcome would be different if its own national law were to be applied. Thank you very much for listening. I'm very, very happy to take any questions which you have, and that completes my presentation for the purposes
Paul,
of
thank you
this
very much
webinar.
for the very enlightening, inspiring presentation, comparing the two case law jurisprudence of the Luxembourg and Strasbourg court on the issue of judicial independence, also touching on the aspect of prosecutorial autonomy. The floor is yours, dear participants. Please feel free to pose your questions through the chat box, add a question to any of the two speakers, or indeed a comment or a point of clarification that you might want to seek in relation to what you've heard. There was previously a question whether you would be provided with a link to the presentations and the slides. Indeed you will receive those. And another question was that I believe was clarified among the participants themselves is access to the two judgments that Paul mentioned, the domestic judgments by the UK courts, and indeed there were some links already shared, and that should be also sorted. And I think Bailey also the suggestion to go through that open source I think should work. In any case, I do believe that Paul would be happy to share the full judgments or links if needed. So I don't see any questions, but just to give you time, maybe I will ask Laurent if he has any comments on what he heard from Paul, just to give him a chance to come in if he likes.
Sorry. No, I mean, I'm in full agreement with what Paul said, so no particular comments, except possibly to point out to a very recent ruling from a chamber of the European Court of Human Rights. I call this ruling the Icelandic judge's ruling. I'm going to try to find the reference, but essentially for the very first time, I need to digest the ruling because it was only issued a few days ago. But essentially, the chamber of the European Court of Human Rights seems to be suggesting, or seems to have been holding, that any procedural defect regarding the appointment of any so-called judges would automatically lead to a breach of Article 6, paragraph 1 of the ECtHR. So this is potentially a quite radical ruling, which would suggest that if a plaintiff can prove to some extent the existence of procedural defects regarding the appointment of any judges involved in the litigation he was a party of, then it's enough to lead the court to conclude that the right to a fair trial has been violated. I'm just going to try to find a link which I'm going to share in through the chat.
Perfect. Thank you very much, Laurent. That would be very useful. So you will receive a link that Professor Pech mentioned via chat box. I see a first question that doesn't address anybody particular, so I'll ask the question and possibly then Paul may start addressing it, and if Laurent wants to come in as well, feel free. What can be done on a practical point of view to enhance the rule of law in Europe on the local level as for judges in the member states? So indeed the question is what a national level judge can do from the practical point of view to enhance the rule of law?
Okay, okay, thank you very much indeed for the important question which you've asked. I think I break down my answer just into two stages. Part one is assuming that we do not have a crisis situation or a difficult situation of the kind which has occurred in Poland and Hungary. So let's just assume for the moment in part one that we actually have ordinary day-to-day business functioning in its proper way, in the sense we don't have the legislature or executive interfering with the judiciary in the way that they have done in Hungary and Poland. So it seems to me in those circumstances, it's a matter of training and informing judges of the content of the rule of law derived from helpful documents like the Venice Commission. There are two different documents on the rule of law, their earlier document, and then also the more detailed document setting out the more detailed checklist. And Laurent was right. I was actually part of the team in the Venice Commission which drew up the second one, the more detailed document. I wasn't actually a member of the Venice Commission when the very first document was created. But it seems to me the second document we created partly because we were asked to do so. It was felt that national judges and national politicians were looking for more detailed guidance as to what the rule of law required or what it meant, and that's what led us to draw up that more detailed checklist. And speaking on behalf of the Venice Commission, and not just on a personal note, we are glad that it's of some help in that respect. So I think a familiarity with and training concerning those aspects of the rule of law set out in documents of that kind is helpful. So that's part one of my answer. Part two of my answer is that if what you mean is, or if the thrust of the inquiry is, how do we help national judges in circumstances like those which have occurred in Poland and Hungary, then I think the answer is you go back to Laurent's slides and you look at the different kinds of techniques which the EU has used in order to try and do what is within its competence to help judges in that regard. Part of that includes the case law of the kind that I referred to and Laurent referred to, but it isn't only about case law. I think what the EU has been quite creative about, and I think rightly so, is to look at other techniques, including financial penalties and the like, which are likely to have an impact on the political order in those countries in order to provide an incentive, in inverted commas, for the politicians in those countries to step back from their interference with the judiciary.
Laurent, if you want to add something, please feel free.
Yes, just very briefly, a practical recommendation. If you can, if the case is relevant, obviously, I would say national judges, the best way they could help improving the overall situation will be to refer as many cases as possible based on Article 19, paragraph 1 of the TEU, so that the Court of Justice is able to actually build on the Portuguese judges' ruling. Because if national judges do not refer cases, then we simply left at the mercy of the Commission's discretion to initiate infringement actions. I know, for instance, that on the back of the Portuguese case, the Portuguese ruling we have been discussing, a couple of preliminary references have been made by Romanian courts regarding the controversial changes being introduced in the Romanian legal system. So I think thanks to this, as long as we can keep the flow of preliminary questions being sent to the Court of Justice, this is possibly the most effective way to help save the rule of law across the EU legal system. Thank you.
Laurent, thank you very much indeed. And maybe one thing that wasn't mentioned, and maybe also because it's relatively new, but could potentially be used, I think, is the new Protocol 16 to the ECtHR, which is often called a dialogue protocol, which enables or provides for the possibility of the highest national courts to ask the European Court for advisory opinions on questions with principles relating to the interpretation or application of the rights and freedoms defined in the Convention. So that could potentially also be used, maybe, perhaps, and so not only Luxembourg path, but also the Strasbourg part, without necessarily waiting until as in case of BACA, judge had to exhaust all the domestic remedies before approaching the Strasbourg court himself. It could be in the pending case in front of you a question that you might want to pose to the. It's kind of a preliminary ruling possibility now with the Strasbourg court, and I think until now it was used only once by French court, but it's relatively new, so as a first proposal. So that's something that you can also maybe look into and possibly use. There is another. Sorry, yes, please.
I mean, and just to respond to Francisca's response on the chat, I agree entirely. I think that one core element is the trust of the people in the rule of law, and I agree with you. If the trust is strong, it's harder for other branches to interfere with the rule of law, and I think that I agree with that. As I think you're right, and I think that some of the demonstrations which have occurred both in Poland and Hungary by people opposed to the laws which are interfering with the judiciary is very positive. It's very positive that people are regarding this as dangerous and important and a reason to go out onto the streets. So I think you're absolutely right. At the same time, developments in those countries also show that governments can nonetheless, once elected, press ahead with laws of the kind that we've seen, even if there's opposition from significant
there is another
sections
question
of the public.
from a colleague from Greece. And a question is whether a national parliament could be held liable for introducing possibly unconstitutional constitutional amendments. So it refers to what Paul mentioned at the beginning of his presentation, and any thoughts on that? Maybe Paul, again, starting from you, since it relates a bit to what you mentioned in your presentation.
Thank you again for the really interesting question. This is actually quite a difficult one in the following sense. Bearing in mind the limits of time, I think the answer to the question is as follows. Firstly, you have to decide which court you're taking this to. Are you taking this to Strasbourg, or are you taking it to Luxembourg? So if you're taking it to Strasbourg, you take the constitutional unconstitutional amendment to Strasbourg, but you've got to, if you go to Strasbourg, you've got to lock onto a particular article of the convention which you claim has been breached. So, putting the point another way, the mere fact that there is an unconstitutional constitutional amendment in Greece would not per se, would not ipso facto get your case off the ground. You have to lock your case onto, obviously, a particular article of the European Convention on Human Rights. Whether you can do that or not, of course, would then depend upon the content of the unconstitutional constitutional amendment. The reason why the two concurring judges could do that in Baca was because of the content of the particular change. Whether you can lock on to Article 6 or some other article of the Convention would depend upon the content of the law passed by the relevant parliament. It seems to me the alternative, of course, is can you bring this to Luxembourg? Well, once again, you'd have to show that in some way the unconstitutional constitutional amendment about which you were complaining somehow fell within the scope of EU law so as to trigger the competence and jurisdiction of the CJEU. And once again, that would depend upon the substance, the content of the relevant amendment. One could think of all sorts of amendments of this kind which might, and one could think of all sorts of amendments of this kind which would not. I think I'll stop there and see if Laurent
yes,
would like
in full agreement with you, Paul.
As
a matter of formal national constitutional law, there's nothing you can do against what some may view as unconstitutional constitutional amendments, unless you believe in a supranatural law. I would say, however, yes, if you can argue that the controversial constitutional amendment falls within the scope of EU law, then you can rely on the principle of primacy of EU law, which does cover constitutional rules. Thank you.
Okay, thank you very much. So not easy answer, and probably depends on the particular nature of the law and circumstances of the case, and on the basis of which then more concrete answer could be provided. But hopefully these principles would be sufficient. I don't see any other question, but I wanted to ask actually whether, and to you, Paul, now, whether you believe there is any divergence between the jurisprudence of the two courts, so the Luxembourg court and the Strasbourg court, when it comes to the interpretation of principles of judicial independence, or are they completely converging, meaning that, for instance, if I want to start a case, is it better to go to Luxembourg because I get more generous interpretation or a better chances to win the case, for instance? Are there any issues that you could maybe highlight, or is it all very much on the same
Well, I think it would be a bold person who in 2.5 minutes or less would be attempting to say unequivocally whether the two sets of jurisprudence were entirely aligned. Having said that, I don't see any significant difference between the approach of the Strasbourg court and approach of the EU courts in this regard. I don't see any particular substantive difference. There is a difference of emphasis in the sense that, but the difference of emphasis is entirely explicable precisely because national courts of member states of the EU are part of the EU legal order in the way that I explicated before, and in that sense the importance of the whole focus and reasoning is about the importance of independence in order to allow those national courts to function as they should do so to ensure the effective implementation of EU law within their own countries. And in that sense, that dimension is somewhat different from that of the Strasbourg court because the juridical relationship of courts in the Strasbourg system and the Luxembourg system is rather different. That's the first point. The second point I would make, just one more point. The second point I make, you said if you could choose which court to go to, which one would you go to? Okay, so one, assuming you might bring your case before either, then one answer to that is it depends on remedial effectiveness. And by that, I mean the following. There may, I'm not necessarily saying there must, but there may be an advantage for a litigant to take his or her or its case to the CJEU simply because when the ruling of the CJEU is given, it comes attached to it the supremacy principle of EU law. And the supremacy principle of EU law is a principle which is very effective and very powerful and applies not only to national courts, but national legislatures and national executives. And therefore, depending upon the particular nature of the legal order, other things being equal, judgments of the CJEU may have a bigger remedial punch through the supremacy principle than would necessarily be the case
Paul, thank you very much. And
judgments of the Strasbourg Court.
Discussing, I see a question, right, and a very good comment. Why you see or do you consider the preliminary rulings and a Strasbourg claim as competitive measures and the possible situation in which both of the legal means are allowed? And yes, I would say, but of course, please, maybe Laurent, you can comment on that. One doesn't exclude the other.
No, very little to add to Paul. I'm in full agreement again with what Paul has said. I would just, my brief answer would be, I don't see them as competitive roads. I just see them as mutually reinforcing available options. So I don't think we should see any sort of competition between the different options, and the same goes for the case law. We used to be concerned about potential divergences in the about 20, 30 years ago. But as far as judicial independence, I cannot think of any significant or even a minor disagreement between the Court of Strasbourg and the Court of Luxembourg. Thank you.
I agree with that. And in relation to this last question from Joanna, nothing that I said was intended to imply that there was some sort of zero-sum game or competition between them. They are, in many ways, mutually reinforcing avenues for the protection of judicial independence within Europe and within the signatories of both organizations.
And we can only hope that in the future the EU will accede eventually to the ECtHR, which will even be more helpful than in terms of making sure the case law of both courts are taken into consideration. One listens to the other, which is already happening anyway. I would like to ask now Paul and Laurent for any last comments or statements that they might want to make before concluding the webinar.
Could I just say in relation to, again, the chat reference that Francisca has set up here, just to say and to reinforce and reaffirm that Kim Lane Chappelle, who Francisca co-authored the piece with the Verfassung blog piece. I haven't seen that particular blog, but I know Kim Lane well, and she has done enormously important work in relation to the Hungarian legal system and to enhancing our understanding of what is going on in that legal system. So I entirely endorse and recommend that literature to those who are interested
any
in
last
this
comments or
area.
You'd like to share with the participants?
No, just our time is limited, so just to reiterate that participants should feel free to drop me a line if they have any kind of questions about the topics we have been discussing. Thank you.
Thank you very much. On that note, thanks to our brilliant presenters, speakers of today, Professor Craig and Professor Pech. Thank you very much for your time and for the very useful insights. Thank you very much, ladies and gentlemen, for joining the webinar and for the questions. We hope that the webinar was useful to you and to your daily work. And that you found this a stimulating and value-adding event. In any case, when we are leaving the webinar, please don't forget to complete the evaluation form to share your feedback. This is very important for EJTN's future webinar program that they are starting to develop. Thank you very much once again. And from all of us at the EJTN, speakers and myself, we wish you a very pleasant evening. Thank you and goodbye.